Yasmin Qureshi.
Thank you, Mr. Rosendale, for asking me to speak. And can I also congratulate my honourable friend for getting this debate and the Backbench Business Committee for allowing this. And I'm hoping that there will be a more detailed debate in the Chamber as well. I want to talk about this particular provision, not because I have any constituents who have been affected by these particular treaties, the extradition or the European arrest warrant. But I suppose I have to declare an interest here as a lawyer who has dealt with criminal cases and having interest in human rights issues generally. I accept, and I'm sure honourable members here accept as well, the fact that we do need to have extradition proceedings and that there's a need for a European arrest warrant as well. But what I think we are concerned about is how these particular provisions are being exercised in practice. And in particular, I want to talk about the UK-USA Treaty on Extradition signed during the last government and the practical ways that the European arrest warrant can be improved to ensure that these warrants are issued in a proper circumstances based on evidence and ensuring safeguards. And thirdly, I want to touch on the recommendations of the Joint Committee on Human Rights, which has looked at this issue in depth and has come forward with recommendations. And I would really urge the government to accept those recommendations. I am surprised why this matter is being delayed, because when the current government MPs and ministers were in opposition, when these particular issues were being discussed, they objected vigorously to these provisions. And in fact, the Deputy Prime Minister described the USA-UK extradition treaty as lopsided. And as the Honourable Member for Bolsover has said, that so many eminent members of the government were actually critical of these particular provisions and opposed it. And therefore, I'm surprised that they've been in power now for 18 months, why that changes have not occurred. I'm afraid I disagree with Sir Baker, who states that the treaty has not operated in any unfair way. That's not correct, because one of the key difficulties is that a UK national cannot test the veracity of the evidence being used to get their extradition. Yet a USA citizen facing extradition to the United Kingdom can challenge and actually test the evidence being produced to extradite him or her, which is the reason why so few USA citizens have been extradited to this country, because they can effectively challenge the evidence being presented to them, which we are not able to do so. And if the argument is that this treaty is not unfair to UK citizens, again as Sir Baker says, then why was there need to renegotiate a separate treaty with the USA which allowed for specific provisions? Because we know that we have treaties with other countries which do not have these provisions, and treaties with other countries require a greater burden of proof to extradite people to those countries. And I can remember in my previous life as a prosecutor toddling off to Bow Street Magistrates Court to try to get extradition warrants. Bow Street Magistrates now is closed down. And I can remember going there, presenting the document. One of them was exactly the nature of the charges. The indictment had to state specifically what were the offences that the person was being extradited back for. There had to be the evidence that was being used to back our application. And, of course, the prosecutors and a senior member in the Crown Prosecution Service also had to certify that there was a proper evidence here, this was a proper case to extradite. And fourthly, that as soon as the person was extradited back to the United Kingdom, committal proceedings must commence immediately, and all the paperwork and evidence must be served on the person. So that also ensured that somebody who's extradited to the UK would have been tried quickly and expeditiously. Now, none of these guarantees are being given for UK citizens going back to United Kingdom, and therefore I would say, why are British nationals being given less favour than the USA citizen? And it is completely wrong that the government has still sat on this and have not changed the provisions in point. On the European arrest warrants, I know many members have already spoken about cases where their constituents have been caught out about this particular arrest warrant. Again, I don't have a problem or objection to the fact that there is a European arrest warrant in existence. What my concern is how they are actually in practice used and applied. one has to remember that when somebody is being extradited to another country, it will often take time to see if for example, the warrant has been executed wrongly or been applied wrongly, as in the case of the Honourable Member whose constituency I cannot remember, but he talked about one of his citizens the Honourable Member for Richmond, who mentioned about warrant had been wrongly issued effectively in France because they hadn't realised the fact that the person against whom the warrant had been issued was not aware of the fact there had been appeal against their acquittal and they'd got convicted. Those kind of negligencies and errors will occur, and other errors will occur. So therefore, what I would ask the government is to reconsider the negotiation and the basis on which the European arrest warrants are issued, in that the states should have a much more stricter rules and guidelines as to issued to their judges and to their courts as to when they issue arrest warrants, so that, for example, the evidence is there, that the person will be dealt with properly, that there will be procedural safeguards to them, and the fact that they will be looked after properly. And those are things that's required. And the fact that the offences for which people are extradited back have got to be serious offences. And we're not talking about sort of minor things. And also the fact that the arrest warrants are those that can be withdrawn. As I understand, the situation in Poland is that once a warrant has been issued, it's impossible to withdraw it back. Of course, I give it.
My friend for giving way, and I understand the point she's making. Isn't the real problem the complete differences between the standards of legal systems all across the European Union, indeed all across the Council of Europe areas, and the virtual automaticity of a European arrest warrant, which means that we just mask the inadequacies of the current system, and a lot of people end up suffering a miscarriage of justice as a result?
I absolutely agree with my honourable friend when he says that, and that's one of the reasons I'm saying that it's important that how these arrest warrants are actually implemented and put into practice, and therefore safeties and procedural safeguards must be put into place. There must be stringent requirement. It mustn't be just sort of handed out as a matter of course. Somebody comes to court and says, well, I want an arrest warrant, without people looking in properly as to whether the arrest warrant is deemed to have occurred here. Because even in our country, when police officers go to courts occasionally to ask for arrest warrants, the magistrates, the judges look at what is being presented to them and then agree to these things. And I think if you're in a nation state, for example, if you're arrested in England, then even if you're arrested, say, in Watford, you know that your case can be resolved quite quickly. If there's any procedural irregularities, if there's some errors, the errors can be sorted out very quickly if you're in the nation state itself. However, when you're in a foreign country, foreign language, foreign jurisdiction, foreign everything, it's not going to be so easy to sort out mistakes. It may take months and months and months before mistakes are sorted out, which is why it's so important that when they are issued in the first place, that they are issued properly with strict procedures. Now, coming on to the Joint Committee on Human Rights, they have come forward with some very practical and good solutions which will help British nationals. They suggested the forum provision, which is basically allowing the fact that British judges should be able to decide in an individual case whether this case should be tried in this country and whether there is need to extradite somebody abroad. We've heard the case of Babar Ahmad being mentioned, and Gary McKinnon and others. And one of the interesting things about all of these people is that their offences alleged offences are deemed to have occurred in this country. Therefore, what is wrong with us prosecuting them? Why can't our prosecuting authorities prosecute them? If the evidence is there, then they should be rightly prosecuted. And I think nobody's saying these people shouldn't be prosecuted. We all believe if there is evidence against somebody, then they should be duly prosecuted. And it seems that in the case of Babar, from what I've been reading, and as he's not my constituent, and again, I recognise the hard work put on his behalf by the Honourable Member for Tooting, and that is that, again, what he did supposed to have occurred in this country. He spent 9 years in, effectively, I would say, prison. And as the Honourable Member for Slough made the point, he's effectively served almost 14 years of a prison sentence for allegations which, if proved correct, may only have carried maybe 5 years, 6 years at the maximum. So he's effectively served his sentence. But the important thing in that case, and Gary McKinnon and others, is that the evidence that apparently is being used against these people is the evidence that the British authorities have found in any event, especially in Babar Ahmad's case. When he was arrested, there's supposed to be some information or allegations or evidence against him, and that is the basis on which they're using to have an extradition. Well, if that evidence is so cogent and so good, there's nothing to stop British authorities from prosecuting Babar Ahmad in England. If that's not happening, then there's a reason. And the reason it's not happening is because presumably there is insufficient evidence against Babar Ahmad. Because I know, as having worked in a prosecuting authority for about 10 years, if there's evidence, we prosecute. And if there isn't evidence, we don't prosecute. And in my opinion, that's exactly what's happening here. And with the Americans sort of asking for extradition, whilst I obviously understand the sensitivities of the USA because of the problem they've had, it does not mean to say that British nationals' liberties and rights should be put aside for the interest of another foreign state who will not give reciprocal rights to other nationals. And therefore, and they may have their own political agendas, and they may have their own agenda as to why they want Mr. Ahmed in, and we know that if this extradition goes through, probably Babar Ahmad will probably spend the rest of his life in solitary confinement or in high-security prisons in the USA, and therefore his whole life has been destroyed. Therefore, I would really urge again the government to rethink about the issue, about the foreign provision, about the fact of allowing our judges to decide in cases where the cases should be tried here, and of course in cases where there is evidence against someone, our prosecuting authorities should be the ones to try those cases. And therefore, I really do urge the government to reconsider this provision. Thank you.
Thank you, Barbara.